Wagwan world, what's goody? So you don't know today is May 30th, Thursday. It's the big day. We was all waiting for the outcome of Vybz Kartel's bail verdict to see if him and Sean Storm and the rest of his Cody's is going to be released. And at this point, as the world is finding out, he has been denied bail. Yeah, a little somber. So today, there's no free world boss. But you still keep your fingers crossed off here and rooting for World Boss that on June 10th, when they come back at the appeals court to see if they're going to be retrialing him for murder, which is the deciding factor. So, yeah, so you go. So that's where we at right now. Let's get some facts and some news real quick. So Judge Andrea Thomas, after she heard both arguments in the habeas corpus application, that's what it's called, the habeas corpus, that's what the application is filed on Kartel's behalf, she ruled that the continued detention was not in breach of the Constitution. And she said in absence of a verdict or acquittal by the Privy Council, the charge of murder remains in effect. So they can still hold him on murder, because when they quash the verdict, they didn't quash the charge, I guess. That's what I'm taking from here. But I got a clip from a lawyer earlier before the verdict was released, and he kind of broke down everything, how it's going to take place when it comes to the habeas corpus application, and as well as what we can look forward to what's next. Okay, so let's get into that and then we come right back. All right,
joining us now to help us understand what this application is about and the possible results from today's hearing is attorney at law Lloyd McFarlane. Good afternoon, sir.
Good afternoon, Carlin.
Right, so we want to first ask you to help us better understand what is a habeas corpus application.
The whole principle of habeas corpus has been around since Magna Carta in England. That was when certain nobles and so on wrestled certain rights from the king. And one of those rights was that no person would be detained or imprisoned without lawful justification. In other words, essentially, you should be charged with something or you should be released. We have been using the application or writ for habeas corpus for as long as our courts have been in existence. And what normally would happen is that if someone was arrested by the police and was thrown into some police station, some lockup, and not brought before the court within a reasonable period of time, his lawyer would then make an application for a writ of habeas corpus, which essentially says, bring him before the court and release him, or show why he should not be released. In that event, the police would have to come forward and say something like, well, he's been held for identification period or something pending some charge, and the judge would then make a ruling. In our case, in relation to, although Kartel and others were charged with murder, tried and convicted, when the matter went to the Privy Council in England, the conviction or the convictions were quashed. But the Privy Council did not actually dismiss the charges. They have sent it back to the Court of Appeal to decide whether or not there will be a new trial order or the Court of Appeal will dismiss. So what has happened is that with that situation of what the defense lawyers for Kartel called a lacune, they have made made an application to have Kartel and the others released from prison on the basis that, look, if his conviction was quashed, why is he still being held? On what legal basis are they actually now being held? The problem that the Kartel lawyers have is that, as I've said, the charges were not dismissed. So it may well be that the court will decide, well, look, he's still properly subject to charges until those charges are dismissed. So we will see what the court will have to say.
Actually, I wanted to ask, what are the possible outcomes from today?
Well, the possible outcomes from today are essentially, well, the most likely outcome is that the judge who is dealing with the matter will say, well, let us wait and hear what the full panel Court of Appeal says will happen to the matter. In the meantime, the writ of habeas corpus application may well be denied pending the outcome of what the full Court of Appeal will say. So if the Court of Appeal says the charges are dismissed, then the matter becomes entirely moot. If the Court of Appeal says, look, we are now going to order a new trial, then the matter must go through the same processes as any other matter where charges are before the court. In other words, they will be going back before the Home Circuit Court. Applications for bail can be made at that time, and at that time, the DPP's office will look to see what type of case they will have to present. In other words, it's going through the whole process over again.
So let's just say I just want to ask you to reinforce this for me. Let's say it's denied, the appeal is denied. What can the lawyers do? Can they appeal?
In terms of the habeas corpus application?
Yes, sir. If the decision is that the application is denied.
Well, a habeas corpus application is a specific type of remedy that is sought. And ordinarily, you because they have actually gone to the Court of Appeal in terms of making it, and because the Court of Appeal is in charge of the matter, there really is nothing else to do but to wait to hear what the Court of Appeal says on the outcome of everything else.
And if granted, how soon could things, become natural? A natural
Well,
flow?
it really is going to be a matter of what the Court of Appeal orders in relation to whether or not there should be a new trial. It really comes down to just waiting on what the Court of Appeal would say.
So on June 10, there will be another court ruling. Explain the difference there in comparison.
Well, what has happened here is that the lawyers, in making and asking for the habeas corpus, did not have to go through to the full court. A single judge of the court could handle that and make a determination on that. But on June 10th, you say is the date. That is when the full court will hear everything in relation to the arguments, essentially, that there should be no retrial order. That is really the nub of everything. Because if the Court of Appeal decides that no retrial should be ordered because of the length of time the matter has gone on or anything else, that is the end of the matter. If the Court of Appeal, however, says we are ordering a new trial, and the Court of Appeal may well take that position because it is noteworthy that the Privy Council could have dismissed the charges, but the Privy Council itself would not be able to order a new trial. The fact that the Privy Council sent it back to the Court of Appeal to make these determinations would suggest that the Court of Appeal is likely to order a new trial.
Just before you go, sir, and thank you so much again for joining us. Of course, we do have a full audience at this time. Is there anything you would want to say to Jamaicans otherwise?
Well, we should have confidence in our court system and our judges, and I'm sure that they will take into account fully all the law and the evidence that is available and make a proper decision on that.
Thank you once again, Attorney at Law Lloyd McFarlane.
And I hope, so there you have it. I hope that brought some clarity to as far as the proceedings, give us a little background as far as some history of how it came about, what it means to file, what the options the judge had, and as far as what outcomes, what steps can be taken after a particular outcome was reached. And because now we do know that he was denied bail, the team is going to have to revamp up, which I'm pretty sure if they were well prepared, because they're lawyers. If you're paying them big top money, especially for the last 13, 14 years, I'm pretty sure they're ready for both outcomes. If they didn't get it, they got to just keep pushing forward. So again, June 10th. But tell me what you think in the comments. What was your response then to finding out that he was denied bail? I heard the police presence was crazy at the courtroom. They must say, yo, helicopter fly around. They must say, yo, mad journalists. I can imagine that bloggers was there and everybody who was hoping that they was gonna get to celebrate on the road. But I guess the police, people are speculating that the police kind of know what was going on already, so they expected like a riot or unruliness, so they make sure they were there to keep everything at bay. Man, I was hoping to have a different type of vlog, so it's all good. Well, hopefully he's still in the fight, and I just want to know what you think. Tell me in the comments. It's gonna be short and sweet because, of course, as the day progressed, it's still early. It's only been about 45 minutes, not even an hour since the verdict has been released on Vybz Kartel and Sean Storm not getting bail. So we're gonna tap back into a minute. Soon as some more info comes up, we'll reconvene. Want y'all have a great rest of your day, and let's chop it up and watch some more video, man. I'll see you again later. Peace and come on, kaboom.
One destiny.